past life, I used to be a solicitor, but for the last 20 years now, I've been lecturing land law, including succession law. So land law tends to be not such a popular subject here in the university. Some of it is quite technical, but one area that is very interesting and quite accessible to everyone is the law in relation to wills. So most students have, can get into this because it's so practical. Everyone's going to have to make a will. Everyone's everyone's parents are going to have to make a will. So my aim today is to just give you some basic information, which hopefully takes a bit of mystery out of making a will and what wills are about. So I suppose a lot of people tend to be a bit daunted about the prospect of making a will. They might be intimidated by the idea of going to see a solicitor, or they might be worried about the cost of it. Or, I mean, it might feel just a little bit morbid to be planning for your death. And in that initial meeting that you have with a solicitor, when they're taking instructions about making a will, there's a lot of information to take in. So just Una has reminded me there, this talk is being recorded, so just to be aware of that. And during the talk, you can put your hands up and ask me questions, but I'll also leave some time at the end for any questions that you have. So anyway, as I was saying, at this initial meeting with your solicitor, there's a lot of information to take in, and you're possibly feeling a little bit on edge. So hopefully today's talk will give you some background information and take the mystery out of it a little bit. So first of all, I'm going to talk to you about why you might make a will. Okay, what happens if you don't make a will? And then I'm going to talk about the requirements for making a valid will. And then finally, I'm going to discuss some protections that are there for a disinherited wife or husband or a child. Okay, so you do generally have freedom of testation. You can leave your property to whomever you wish, but there are some protections that are there to protect a spouse or a child. So first of all, then, what happens if you don't make a will? Basically, your intestate successors will inherit your property. Okay, so if you die without having made a will, the rules on intestacy, which are set out in the Succession Act 1965, will apply. And that 1965 Act sets out an order of entitlement, and you work your way through that order to see who your closest next of kin is. Okay, so your closest next of kin will inherit as your intestate successor. So first on the list is your spouse. So if you're survived by a spouse and no children, your spouse will take your entire estate. Okay, so if I die and I just have my husband surviving me, then he will take everything. If I am survived by my husband and my children, 2/3 of my estate will go to my husband and 1/3 is divided equally between my children. Okay, so my husband takes 2/3 and my kids take 1/3 between them equally. Okay, and that mightn't be very fair. Maybe one child has greater needs. Okay, maybe the other children are all grown up and independent now, but the intestate succession rules don't allow for any flexibility on that. The third is divided equally between your children. So if I die and my spouse has predeceased me, my husband is dead already, and I'm survived just by children, they take the entire estate equally between them. And then if I didn't get married and have kids and I'm survived by my parents, they will take the entirety of my estate between them. Okay, so if I'm survived by both of them, they'll take half each. If I'm survived by one, they'll take the entire estate. And then next on the order of entitlement are your brothers and sisters. Okay, your siblings, they'll take equally. And then finally, you get to nieces and nephews. And at that point, if you aren't survived by any of these people, it's the solicitor's job to identify who your next of kin is. and that is they are the person who's closest to you in degrees of blood relationship. And there's actually a formula set out in the Succession Act to identify who your next of kin is. It could be a cousin, a first cousin, or it could be a grandparent. If you don't have any next of kin, then the state will take your property as the ultimate intestate successor. So there are the rules governing intestate deaths. So that's what will happen, I suppose, if you don't make a will. You know, your estate will be administered by whoever inherits as your intestate successor. They also act as your personal representative. So it's their job to pay any debts owing and to gather in your assets and also to distribute them in accordance with the rules governing an intestate death. So I just thought it might be useful as well to set out a kind of a very simple will up there on the slides, if you can see them. So this is the format of a very, very basic will. So this will is made on the 1st of February 2012 by me, Joe Murphy, of 11 Milford Grange, Castletroy, Limerick. Okay, and the first clause there, I hereby revoke all my former wills and testamentary dispositions. That's called a revocation clause, and that's standard. Okay, so if he made any wills previously, they are now revoked. They don't operate anymore, and this will has precedence. So the next clause then is also standard in any will. I appoint Liam Murray and Tom O'Sullivan to be the executors of my will. Okay, and I direct my executors to pay my debts, funeral and testamentary expenses. So your executors are your personal representatives. They're the people who administer your estate, your property after you die. So if you're making a will, you will appoint usually 2 executors. It's better practice to apply more than one. Okay, so the next clauses then are your legacies. Okay, so I devise my house at 15 Milford Grange to my nephew Tom Ryan. So that's a legacy of a house. Okay, and a legacy of a house or land is called a devise. So the next gift there is I give and bequeath my antique dining table to my sister Mary Ryan. So that's a bequest. Anything that isn't land is known is personal property. It's called, or chattels. So the particular legacy would be called a bequest. So that's a bequest of a dining table to my sister Mary Ryan, and then I give £5,000 to my sister Eileen Ryan. And then the final clause there, I give, devise and bequeath the rest, residue and remainder of my estate to my brother Ian Ryan. That's called a residuary clause. And everything that you haven't given away previous to that goes into the residue of your estate and is distributed in accordance with your residuary clause. So it's very good practice to include a residuary clause in your will. So everything that you haven't given away specifically in the will goes into that, and it goes here in this case to the testator's brother Ian Ryan. So the final line says, I'm signed by the testator in the presence of both of us and signed by us in the presence of the testator. Okay, that's called an attestation clause. Okay, and it's just standard included in a will. So the testator has to sign the will in the presence of 2 witnesses, and then the witnesses sign the will in the presence of the testator. So that's what a very simple will would look like. Now, just I suppose to mention a couple of points about wills, there could be what's known as a partial intestacy. Okay, so you might have made a will, but you may die partially intestate, and that would happen if there was no residuary clause. Okay, so if we go back to the example there, so the residuary clause there was in there towards the end. I give, devise and bequeath the residue and remainder of my estate to my brother Ian Ryan. If you didn't include that clause, it would mean that the rest of your estate would go under the rules governing an intestacy. Okay, so it looks like probably the closest next of kin there would be your siblings. So it would be divided between your siblings. So the rules governing intestacies would govern that part of the estate that wasn't disposed of in your will. Okay, so that's one thing that can happen. You could have a partial intestacy because you didn't include a residuary clause. Another thing about wills is that they are revocable until death. Okay, so even though in this will you're saying, you know, or it's typical, it's not said there actually, this is my last will and testament, okay? Often that will be included in a will, that phrase. It doesn't mean very much, okay? Because you can revoke your will at any stage up until you die. So even if someone has promised you that they're going to leave you something in a will, you know, you can't rely on that promise because they could change their mind and make a new will and leave it to someone else, or they could decide to sell the property, and in that case the gift is cancelled. Okay, even if it's mentioned in the will, it's cancelled. You get nothing. You don't get the proceeds of sale or anything. So a will is revocable. You can revoke it and make a new will up until you die. Do you have to employ a solicitor to draft a will? No, you don't. And often you'll come across handmade wills, but they will be the subject of often litigation. Okay, so it's not ideal, but you can draft your own will. A handwritten will, for example, and that's typically called a holograph will. So you have to be very careful when you do so, because it's easy to not comply with the requirements for making a valid will. I suppose the advantages of employing a solicitor is that they'll be very familiar with the rules. Okay, they'll do it on a daily basis. They'll be making wills. They can ensure that the will itself and each gift in the will is valid. They can also give you advice on what the succession rights of your surviving spouse or children are. And they could advise on whether a trust is necessary. If you have minor children, for example, you will often want to set up a trust to look after them until they reach the age of 18 years of age. Or you may have a child with a disability and you may be considering what's known as a discretionary trust for them that will operate throughout their life. So you would need specialised advice on that. And of course, your solicitor will be able to give you up-to-date tax advice as well. Anyone who's inheriting under a will have to pay capital acquisitions tax, and the solicitor will be aware of the thresholds, the current thresholds that operate, how much, for example, a child can take, being, you know, what they'll be exempt from capital acquisitions tax up to a certain threshold. And I suppose the last point there is perhaps a little bit cynical. If the solicitor is negligent, any intended beneficiaries under a will, anyone who is supposed to get a gift under the will, is owed a duty of care by that solicitor, so they could sue for negligence, and they would be awarded damages for the amount of the legacy that they should have got if the will was valid. Okay, so if the solicitor messes up and makes a mistake, and if as a result the will is invalid or the particular gift is invalid, then the person who would have otherwise benefited under the will can sue the solicitor for negligence and be awarded damages. So, okay. Now, in relation to making a will, there's basically two steps. The first step is that the testator must have testamentary capacity. And the second step is that the will has to comply with certain formalities. So the first step is they must have testamentary capacity. So there's two parts to that, and they're set out under Section 77 of the Succession Act. First of all, the testator or the testatrix, if it's a woman, must be 18 years old or else be married. Okay, so that's the lower limit on age limit on making a will. Now, there's no upper age limit, okay? You can make a will even if you're 103, okay? There's no upper age limit, but you must be of sound disposing mind. That's the second requirement. There's a legal test that was set out in a case called Banks versus Goodfellow. In order to be of sound disposing mind, there's 3 prongs to that test. The testator must know that he or she is making a will. They must know the extent of their estate within reason. And finally, they must know who might expect to benefit from the will and decide whether or not to include them. Okay, so being of sound disposing mind isn't the same as having mental capacity, okay? You could have a mental illness still, but qualify as being of sound disposing mind, okay? You just must be able to know what you're doing in making a will. So you could, for example, have Alzheimer's or dementia or any kind of mental illness. You couldn't have paranoid schizophrenia and still be of sound disposing mind. Um, the, the, the solicitor who's taking your instructions must just satisfy himself that the legal test set out in Banks versus Goodfellow has been met. So you must know you're making a will. You must know the extent of your property. Now that yardstick, knowing the extent of your property, that has certain limitations, because if you have an awful lot of property, for example, loads of stocks and shares, you mightn't be aware of exactly everything you have. But usually when you're giving, the solicitor is taking instructions, he will be identifying your assets for you, and he will get a good idea if you know the extent of your property. And then the final one, you must know who might expect to benefit from the will and decide whether or not to include them. That doesn't mean that you can't make a surprising will, okay? You know, you do have freedom of testation. You can do what you want with your property within certain limits, and people do make surprising wills. But I suppose if your will is what would be expected, that would be evidence of your testamentary capacity as well. Okay, so for example, there was one case in O'Donnell versus O'Donnell, it was called, and the testator had paranoid, he was a paranoid schizophrenic, but his condition was very well controlled and managed by medication, and he made a very kind of sensible will. And the fact that he made a sensible will was evidence of his testamentary capacity. In Banks versus Goodfellow himself, in that particular case, the testator thought he was being pursued by evil spirits, but the court was still satisfied that he had testamentary capacity, that he was of sound disposing mind. Okay, so this could be an issue if someone's suffering from dementia or Alzheimer's, or possibly if you've had a stroke, that could impact on your testamentary capacity as well. And solicitors, if they feel there's possibly an issue here, they would take very detailed notes on the meeting with you. Okay, the notes that a solicitor takes of a meeting with a client is known as an attendance. So they would take a very detailed attendance, and also they might ask that you go to your doctor or your consultant and ask them for an affidavit of testamentary capacity, okay, just to rule out any future challenges to a will. Because if after you die, your family are unhappy with the will, they could challenge it and say that you weren't of sound disposing mind when you made the will. And if there's a detailed attendance by the solicitor and an affidavit of testamentary capacity by your doctor there, at least there's less chance of the will being challenged. Okay, so that's so really the solicitor will take a very detailed attendance. They will make sure that the doctor or the consultant of the client has sworn an affidavit, a sworn statement that the person has testamentary capacity, and they will rely on that. Another thing that a solicitor might do which is kind of slightly relevant in this context, is make sure that no one else comes into the office with the testator when they're making their will, okay, to guard against undue influence, okay. And often you will have, you know, very helpful neighbors, for example, or family members who want to help the person into the office, and maybe the person is a bit hard of hearing and they're offering to be helpful. But it's important that the client is seen on their own to guard against the possibility of undue influence, okay, or pressure being placed on them to make a will in a certain way. So that's testamentary capacity. So the next requirement then is that certain formalities have to be complied with in making a will. So these are set out in section 78 of the Succession Act. So a will has to be in writing. Okay, so it's no good to make an audio recording of your will. Okay, it has to be in writing under the Succession Act. It has to be signed by the testator, or by some other person in his presence and by his direction. Okay, so a testator may be too physically infirm to sign himself. So in that situation, maybe the solicitor could sign for him and by his direction. And the signature of the testator must be made or acknowledged, just pointed out, in the presence of two witnesses. Okay, so you have to have two witnesses to make a will, to make a valid will. So the testator makes his signature or acknowledges it in the presence of two witnesses, and then the witnesses sign their names in the presence of the testator. Okay, now in relation to witnesses, there's one very important rule. Okay, a person who witnesses the execution of a will can't take a legacy under that will. Okay, and the idea behind that is to guard against undue influence. Okay, so if I make my will and my sister is there and she witnesses that my signature, if I've left her something in my will, then that gift is invalid. Now, the will itself is valid, okay, there has been compliance with the attestation requirements, the requirements to witness a will, that's okay, but that particular gift to my sister will be invalid. And likewise, if my sister doesn't witness the will, but her husband does, then the gift to my sister is invalid. Okay, that rule is set out in section 82 of the Succession Act. So basically, a witness or their spouse shouldn't witness a beneficiary, someone who's taking a gift under the will, or their spouse shouldn't witness it. So what about if you've made your will and then you change your mind, it's been signed and it's been witnessed, and you change your mind, you decide no, that you'd actually like to give 10,000 euro instead of 5,000 euro to St. Vincent de Paul. Can you make an alteration to the will? You can, if it's already been executed, though you have to execute the alteration in the same way as you would execute the will itself. So you must sign your name next to the alteration, and the witnesses should sign also next to the alteration. Okay, so you have to be very careful if you're making an alteration in the will. It might be simpler just to print off a new one and tear up the old one. So they're the testamentary requirements. So as I was saying, in general, you have testamentary freedom. You have the freedom to do what you want in your will, okay, with your property. But there are certain protections that are there for close family members, and they're set out in Part 9 of the Succession Act 1965. So the protections are there for a surviving spouse, okay, or also a civil partner, and also for your children. Now, the surviving spouse and civil partner are treated differently to children, okay? There are different types of protections for them. Just to mention, if you're divorced, a former spouse, okay, your divorced spouse, can apply to court for provision to be made out of your estate after you die. Okay, so there is that facility there. And also, if you die and you're survived by a cohabitant, if you were living together with someone for a certain number of years, they may also be able to apply to court for provision to be made out of your estate, just to be aware of that. Okay. But if we're just talking about a regular run-of-the-mill husband and wife situation, or civil partners, what the husband and wife or civil partner would be entitled to after your death is a certain fixed fraction of your estate. Okay, now you may have left everything to your spouse in your will. Okay, and that would be fairly typical. Usually what people do is they leave everything to their spouse. They don't even leave anything to their children, because they know that the surviving spouse will look after them in their will. Okay, so that would be unless it's a second family situation, but often you would leave everything to your spouse. But if you didn't, if you were on poor terms with your spouse, and you say left them, oh, I don't know, a stamp collection or something, okay, instead of taking the gift under the will, um, that spouse would be entitled to a half of your estate if there are no children. Okay. And if you're survived by a spouse and children, they'd have an entitlement to 1/3 of your estate. Okay. Instead of taking the stamp collection. Okay. So, or if you left them nothing at all, they would be entitled to take a half of your estate. Um, and they'll find out about this right because the executor of the will has to tell them about it, that they have a right of election to take their legal right share, it's called. Okay, so it's an entitlement to a fixed share of the deceased estate, and the share is half the estate if there are no children, and 1/3 of the estate if there are children. So you would be told about that if you were going to make your will and you wanted to say possibly not include your spouse in your will. The solicitor would tell you that, listen, they have this legal right share, they have an entitlement to a certain fraction of your estate. So there's no point in leaving them out. Um, they have this entitlement to that fraction. So often then the testator would leave the exact legal right share to the spouse. Um, so another important protection that's there for a surviving spouse is a right to appropriate a dwelling in which they were ordinarily resident in or towards satisfaction of a legal right share or an intestate share. Okay, so if you're succeeding under the intestacy rules, you have a right to appropriate the family home, basically. So now this is only going to be relevant if the family home is not held in joint names. Typically, the family home is held by a husband and wife in a co-ownership relationship known as joint tenancy. And if you're joint tenants of your family home, and one co-owner dies, then the remaining co-owner becomes the sole owner of the property, and succession law has nothing to do with it. Okay, you inherit the house under what's known as the right of survivorship. Okay, so if you hold the family home as joint tenants, there's no need to rely on Section 56 of the Succession Act. Okay, this is really only in the case of, say, maybe a more old-fashioned situation where the house is in the husband's name. Maybe he inherited it from his parents or something, and it was never put into the joint names of the husband and wife. In that particular situation, the wife can take the family home in satisfaction of the legal right share. Okay, she's an entitlement to maybe half the estate or 1/3 of the estate. Or if it also applies if the husband dies intestate. Okay, in that situation, she'll be entitled to the entire estate or 2/3 of it if there are children. You can appropriate the family home in or towards it. Now, just to mention that that right to appropriate the family home is restricted for certain types of dwellings. Okay, if the dwelling is part of a business. Okay, if it was, for example, a farmhouse, or if it was part of a hotel, or if part of the dwelling was used for a business. In those situations, you'd have to get a court order in order to appropriate the dwelling house. And the court will not make an order allowing the house to be appropriated unless they were satisfied that it wouldn't make the other assets less valuable or more difficult to dispose of in the course of administration. Okay, so it won't make an order allowing for the appropriation unless it wouldn't impact on the value or marketability of the other assets. Okay, so just to be aware of that. So if you're talking about a farmhouse or a house that's used as part of a business, you have to get a court order to appropriate the family home. What about if the house is worth more than what you're entitled to under your legal right share? Okay, so remember, the legal right share might be just a third of the estate. If if um, if you have children, and a third of the estate could be maybe 150,000 euro, and the house itself might be worth 170,000 euro. What's the situation then? Well, you could make up the difference. You could pay the money into the estate. So the spouse could pay 20,000 euro into the estate, or they could, if the spouse is a trustee for an infant child, they could use the share that the infant child is entitled to make up the difference. Or in circumstances of hardship, the court may decide to waive the balance. Okay, they may decide that the spouse doesn't need to pay the extra money and can appropriate the family home. So just in relation to the legal right share as well, if you're talking about a separated couple, usually the separated couple would renounce their legal right share. Okay, they're still technically married, they're not divorced yet, but if they're separated, they would renounce their succession rights in the other's estate. Okay, and just to be aware also that if you were in desertion of your spouse, okay, if say the husband just deserted the spouse, then they would lose their legal right share. The person who's been in desertion will lose their legal right share. Okay. Also, if you're guilty of murdering your spouse, you lose your entitlement to a legal right share, or others less serious offences. Any offence against a spouse that's punishable by 2 years imprisonment will lead to you losing your legal right share. Okay, so there are certain circumstances in which you would lose your legal right share. Also, if you're guilty of constructive desertion, okay, so maybe the husband stayed on in the house, and he was there was domestic violence going on against the wife. If she left, she's not in desertion in that particular situation. The husband is in constructive desertion. He's guilty of conduct which forced the wife to leave. Okay, and in that situation, he loses his legal right share, but she won't lose it. So just to be aware of those little rules. So what about surviving children then? So if your parent made a will and you didn't benefit under that will and you feel hard done by, you may have a remedy under Section 117 of the Succession Act. Okay, Section 117 of the Succession Act provides that if this testator has failed in his moral duty to make proper provision for the child in accordance with his means, by will or otherwise, the court may make an order under Section 117 of the Succession Act. So children are treated differently to a surviving spouse. Okay, with a surviving spouse, you have an entitlement to an automatic fixed share of the estate. With children, you have to make a court application, and the court decides in its discretion whether the testator has failed to make proper provision. Okay, so I suppose just a few basic rules. The court won't make an order if it will impact on the legal right share of a spouse or any gift to a surviving spouse if they're a parent. So if, say, my father was making his will and left everything to my mother, Okay, in that situation, there's no point in me making a Section 117 application, because it's stated in the Succession Act that it cannot impact on a gift to a surviving spouse if they're a parent. Okay, so if the surviving spouse is still living, there's probably no point in making a Section 117 application. Okay. Um, Also, a child in making a Section 117 application must do so within 6 months of the extraction of the grant of probate. Okay, so they um, and I suppose another thing is that they they won't be told about their rights under Section 117. You'll remember with the legal right share of the spouse, the personal representatives were under a duty to tell the surviving spouse about their legal right share. There's no onus on the executors to tell the surviving children about their rights under Section 117. Okay, so really it's dependent on the child going to a solicitor for advice and being told about it. Okay, the executors are not under a duty to tell the children about their right to bring a Section 117 application. So there's a time limit. You have to bring it quickly after the death of a parent. Also, a Section 117 application is not available if your parent dies intestate. Okay, so I was saying that property is divided equally between children on an intestate death. So that may not result in a fair distribution of the property. Okay, children may have different needs, but you can't make up for that by bringing a Section 117 application in the case of an intestate death. There has to be a will. Okay, so you have to have been disinherited through a will. Now, just to make go over a few factors that are taken into account by the courts when they're deciding whether to make an order under Section 117. So they'll take into account things like the size of the estate. Okay, was there a lot of property? The number of children there were, their ages, their financial positions, and other moral obligations that may have been owed by the testator. So they'll also take into account any provision that was made during the lifetime by the testator and from other sources. Okay, so you'll see the duty is not really to make provision by will. Okay, you can make provision or by during your lifetime. Okay, so by will or otherwise. So the testator may have made adequate provision for the child during their lifetime, and there may be no need to make provision for the child in their will. Or maybe the testator is aware that the child had been provided for through other sources. Okay, maybe there was a big inheritance from a grandparent or an aunt or something. So the courts will take that into account in deciding if there was a failure in moral duty. The courts will also look at the relationship between the testator and the child. So if the child has been hard done by, the courts will take that into account. If the child has been treated very badly by the testator, that'll be taken into account. There was one case where a child had basically started farming the testator's farm at the age of 14 after the testator was in an accident, and gave up school and everything to look after this farm, and basically the testator fell out with the child when he married someone that he didn't approve of. Okay, so after the marriage of the child, the testator and the child fell out, and the testator didn't leave the farm then to that particular child, and the court made an order vesting the farm in that child. Took into account the fact that all the child's training had been around looking after the farm, and even though the child hadn't behaved that well to the testator himself, they took into account that mostly it was the fault of the testator. So the court will also take into account any special needs of the child. So it may be the case that most of the estate has been distributed to a child with special needs, and that may be fair. Okay, or maybe the testator hasn't made sufficient provision for a child with special needs. And the other circumstances that a court may take into account would be, if a child has a special talent, for example, it may be that special provision should have been made for that child. Another issue that comes into the case law in this area is that basically whether there's been a failure in the moral duty of the testator is assessed at the testator's date of death. Okay, so you may have made a very fair will 10 years ago, but the circumstances for your children may have changed dramatically in the meantime. So your duty extends to updating your will to make sure that it continues to be fair. Usually the court won't take into account circumstances after the testator's date of death in deciding whether there's been a failure in moral duty. But if they've decided that there was a failure in moral duty, they can take into account circumstances at the date of hearing. Okay, so if after the testator's death there was a very bad accident and a child is disabled, if there was a failure in moral duty before the date of death, then the court can take that accident into account at the date of the hearing. So that's just the end of my short lecture. So it's we covered a lot of material there. So I suppose these are just a couple of recap questions that you should hopefully be able to get your head around, after having listened to this. So Joe has been diagnosed with Alzheimer's disease. Can he make a will? So basically, we know you need to be of sound disposing mind. Just because you have Alzheimer's disease doesn't mean you can't make a will, but you have to be of sound disposing mind. There's a legal test for it, and often your solicitor would take a detailed attendance and he would make sure that your doctor or consultant swears an affidavit of testamentary capacity to make sure that you are of sound disposing mind. Nora wants to draft a will at home without a solicitor. What would you advise? That's perfectly okay, but I suppose a solicitor will know the rules and will make sure that the will is valid and each gift is valid. And there are certain technical rules, like the fact that someone who's taking a gift under a will can't be a witness. So they would be aware of those technical rules. They'd also be able to give tax advice and advise on things like trusts. And then Jim wants to leave all his property to charity and nothing to his wife and kids. Can he do that? Well, he can, but the wife is still going to be entitled to her legal right share, okay? And if her name isn't on the title to the family home, she's also going to be entitled to appropriate the family home in satisfaction of the legal right share. And of course, the children can bring what's known as a Section 117 application. So that's that is the end of that. Does anyone have any questions? You can type them up or unmute yourself there if you have any questions. Silence. Could you speak a little bit about probate and in what circumstances? Sorry, now I
Hello, Una. I have
hi.
a question. Hi,
Yes,
this is
sure.
Victoria. Yeah, I would like to ask how much money costs to make a will? To go to the solicitor,
Oh,
more or less.
it depends on whether it's a complicated will but usually people would charge about €300. If it's a very straightforward will,
Okay.
it mightn't cost that much. There was a habit that solicitors had of not charging at all to make a will, in the hopes
Yeah.
that they would have the probate, the job of administering the estate after the person died. But nowadays most people do charge to make a will. But
Okay.
something between 150 and €350
Okay.
typically.
Thank you. And another question. What happens if a person, for example, I'm living in Ireland, but I'm from Spain. I have properties in Ireland and also in Spain.
Oh
Do I
yeah,
need to make two wills, or do I need, or one covers everything?
you'd have to make two wills. There were rules coming in relation to foreign wills, but typically your Spanish property would pass under Spanish law.
Okay.
So you would need to make two wills. Yeah, yeah.
Okay.
But and your Irish property then would pass under Irish law.
Oh, thank you. Thank you so much.
Okay,
Really
Victoria.
interesting.
Yeah, sorry, there was a message there came up, something about probate, but I didn't get the full message. It disappeared on me. Does anyone want to, uh, if where if you do own
I
a
can
will?
read it out,
Oh yeah,
Una, if you want.
perfectly. Yeah,
Could you, it's just from Joan O'Riordan there. Could you speak a
yeah.
little bit about probate and in what circumstances does it apply?
Okay, so basically you go to a probate solicitor if someone in your family has died, and they do the work for the executors. Okay, so say my parent, my my last surviving parent has died, they've made a will, they appoint me as executor. That means it's my job to administer the estate, okay? But what I will typically do is go to a solicitor to do that work for me, and that means that I just have certain forms to sign. There's certain tax forms and certain forms for the probate work. But the solicitor will do all that work for me. So what he will do is he will identify all the assets, okay, with the help of the executor. They will maybe take out insurance to make sure that you're preserving the assets. Okay, so if a house is vacant, for example, you may need to tell the insurance company. Then once a grant of probate has issued, that grant is sent to maybe all the banks that have money belonging to the deceased, and the money comes back into the solicitor's office, and then the solicitor will distribute the assets. Okay, so that's all the job of a probate solicitor. And usually it's slow enough work. They usually don't expect anything to have been finalized until maybe a year has passed from the date of death. But that's what the job of a probate solicitor would be. Is that okay? So I'm not seeing any other notes here. I don't know what.
There's a few more there, Una. I'll call them out to
Okay,
you though.
could you call them out there? Sorry
One,
about
yeah,
that.
no worries. I'll do two together, maybe, just in the interest of time. So Josephine is just saying there, Josephine Conway, what rights do stepchildren have? And
Yeah,
Karen Duffy has a question there. Can an older sibling, 18 years, be a guardian trustee to a younger one if both parents die together, for
yeah.
example, a car accident?
Yeah. Well, stepchildren don't have a blood relationship to a parent. Now, you can adopt as stepchildren in certain circumstances, but if there's no adoptive or blood relationship, they don't have any rights. Now, non-marital children have the exact same rights as marital children. So by non-marital children, I mean children that have been born outside the marriage relationship. Okay, so if you're talking about a couple living together, their child would have the same rights as the children of a married couple. But stepchildren, there's no blood relationship, so they don't have any entitlements under Section 117 of the Succession Act. As regards the older sibling being a guardian or a trustee, yeah, that's absolutely fine if they're over the age of 18. That is fine. You can appoint an older sibling, a guardian, and a trustee to act for younger siblings. Okay, if you do own a will, where do you keep it? Um, Often you'll ask the solicitor who made the will for you to keep it for them in their will safe. They normally have a kind of a safe for wills or title documents, but you could also leave it with the bank. Okay, it's often a service that a bank will do. There was talk many years ago of opening up a register of wills, which would be a very useful thing because wills often get lost, but they never did that. Okay, in some countries they do have a register of wills, but not in Ireland. And if a will is lost, there's a presumption that it was revoked. Okay, so if you can't find a will, and often there'll be adverts for trying to locate lost wills, but if it can't be found, there is a presumption that it was revoked. So that may mean that an earlier will be taken as the new will, or the rules of intestacy will apply. Okay. Is any other questions? think that's all. There was just one thing I wanted to tell you about. Just to make you aware that we have an evening law degree in the School of Law, and this only runs every 4 years, but there is a new cohort to be admitted in September 2021, and the deadline for applications is July 1st, 2021. It's a small class and it's open to mature students, and basically the classes run on a Tuesday, Wednesday and a Thursday evening, from 7 until 10 o'clock. Sometimes you won't have the full 3 hours, sometimes you'll only have 2 hours, and it's a 4-year part-time degree. So it's usually a real nice mixture of students from all walks of life. Some may not have had a lot of formal education before, but they're usually very enthusiastic. So just to make you aware of that, and if you want any more information about it, I'm the course director, so you can send me an email about it. Okay, so if there are there any more questions, I'll leave it at that then, I think. And thanks very much for joining me today, and I hope you got some good out of it. Okay, thanks very much. Okay, Una, I'll leave it at that then.
Perfect. Thanks, Una.
Okay, bye now. Bye guys. Thanks.